Good afternoon, everyone. I'm hoping that you can all hear me loud and clear. I know there's numerous people joining as we speak. Can I introduce myself and my team for today? My name is Claire Lamza. I'm the Executive Director for Nursing at the Mental Welfare Commission for Scotland. Joining me today is Mary Hattie, who will be giving the first part of this afternoon's webinar, and followed by Leslie Patterson, who will do the second part. Thank you. So it's just to make you aware of some housekeeping before we start off this afternoon. If you've got any questions that come up during the chat or during the presentations and you want to email us separately after that, we'll be very happy to pick them up through the inquiries helpline email that comes up at the end. So without further ado, I'd like to hand over to Mary Hattie, who's going to talk you through our first presentation on our good practice guidance, Right to Treat, which has a focus on delivering physical health care to people who lack capacity and refuse or resist treatment. Over to you, Mary. Thank you.
Okay, thank you. Right, so I'm going to talk initially about common law and about the issue of necessity. Under common law, it's reasonable in an emergency to take necessary action to safeguard somebody who's unable to consent and without treatment would come to significant harm. For example, car accident, somebody's unconscious, it's reasonable to take action to preserve their life, to treat their injuries, and you could argue that consent in that situation could also be considered to be implied, in that if the person were conscious, they would want their life saved. So in emergency situations, you can act under necessity. And that's equally true if someone is incapable of consenting through mental illness. If the nature of their physical injury is such that a delay in treatment would lead to a significant risk to their health, you can argue necessity in that situation. The common law principle of acting in necessity was not replaced by the 2000 Act. We can still act in an emergency situation to preserve and to protect life. But claiming necessity doesn't replace the duties under the 2000 Act. If it's reasonable and practicable for the procedure or the intervention to take place under a statutory process, and that's usually under Part 5 of AWI, that provision should be used. If it's not an emergency and there's time to complete a Section 47 or consult with proxies, it is incumbent upon us to do so. When it comes to Part 5 of the AWI, that's the part that authorises medical treatment. And it defines treatment as any healthcare procedure designed to promote or safeguard the physical or mental health of an adult. So under Part 5, to authorise treatment, the medical practitioner certifies incapacity, because obviously for somebody to be treated against their will without the consent, there has to be incapacity there. And the Section 47 certificate authorises the practitioner or other people under their direction to provide reasonable interventions related to the treatment authorised. And that purpose of any treatment must be to safeguard or promote the physical or mental health of the adult. So that's quite a wide definition. Something that comes up quite often, I see it when I'm out doing guardianships, is the issue of GPs and Section 47 certificates. If a GP is prescribing for somebody who lacks capacity, they are obliged to create a Section 47 certificate and to share a copy of this with the care staff if requested, because that's what gives authority to staff in a care home or supported accommodation to administer medication to somebody who can't consent to it. We still find that that's an issue. Some GPs are reluctant to do this, and with the increasing pressure on GPs at the moment, it's becoming more of an issue. If you come across issues around that, please refer the GP or the practitioner to the Commission, tell them to contact us for guidance, or if it becomes a significant issue, you contact us so that we can follow it up, because it is important. There are limitations under Part 5 of the AWI. There's a number of those, and I'll talk them through. Most importantly, it doesn't authorise force unless immediately necessary and only for as long as is necessary. An example, for instance, you've got somebody who's elderly, confused, and they're resisting personal care, you're going to have to use restraint following incontinence. You have to decide, is it immediately necessary, or would it be reasonable to withdraw, give them a cup of tea, time to settle down, try again in 15 minutes. Now, at some stage, if the resistance continues, due to the risks to their skin, etc., you might feel that the immediately necessary test is met, but we need to be thoughtful about it. We can only use force if it's immediately necessary, not just convenient. So that has to be remembered. The other thing about Section 47 is while it authorises the treatment, it doesn't authorise the transport of the patient to the hospital or clinic or anywhere else for treatment. So once you get them to hospital, Section 47 allows the treatment, but to get them there, sorry, I'm getting Teams popping up there, to get them there, you need another authority, and that would be a removal order under Section 293 of the Mental Health Act, where a sheriff would issue a warrant for removal of the person with a mental disorder to a place of safety. That place of safety can be a hospital or a clinic. Once you get them there, they can be held there for up to 7 days under Section 293, but Section 293 doesn't give you authority to treat them. So you would use 293 to get the person to hospital, but would still need a Section 47, and if there's a proxy with powers to consent, the consent of the proxy to actually authorise the treatment. So that's another one of the limitations. The definition of treatment could also be taken to mean examination and investigation, but we would say that a Section 47 is not necessarily required just to examine a patient or to authorise x-rays or blood samples unless the patient's resisting and it's immediately necessary. But for a compliant patient who lacks capacity, we wouldn't say you need a Section 47 just for an examination or an x-ray. There are also certain safeguarded treatments that can't be undertaken on the basis of the Section 47 certificate alone. They're ECT for mental disorder, drugs to reduce sex drive, abortion, or sterilisation when there's no abnormality of the reproductive system. For instance, if there was a reason for a hysterectomy, which would result in sterilisation, that could be done under Section 47, but an operation purely for the purpose of sterilisation could not be done under Section 47 alone. For those safeguarded treatments, and that's ECT, drugs to reduce sex drive, abortion and sterilisation, you need the authority of a designated medical practitioner who would complete a certificate. Now, they would be appointed by the Commission, so in those situations, the treating practitioner would contact the Commission and ask for a DMP visit to have a Section 48 certificate completed to authorise those treatments. There is one other safeguarded treatment, which is surgical implantation of hormones to reduce sex drive, and that needs authority from the Court of Session. That's different from just drugs to reduce sex drive. That requires a further authority. And we're on to the role of proxy decision makers. If there's a welfare power of attorney or a guardian who's a power to consent to treatment, then Section 47 is still needed because it's the thing that certifies the adult lacks capacity. But in addition, the attorney or the guardian must be asked for consent unless it's not practical. The Act doesn't confer authority to treat to a treating physician unless they have consulted with the welfare proxy and obtained their consent. Now, if the proxy is not contactable, for instance, they're off on holiday, and a delay would be injurious to the individual, it would be reasonable in those cases to go ahead without having received consent. However, one of the things, again, that we see quite often in hospitals and in care homes is that A GP will come in, find somebody has a chest infection, urine infection. There is a proxy. They know there's a proxy. They prescribe antibiotics or whatever treatment and tell the nurses to notify the proxy. That's not acceptable. They have to obtain the consent of the proxy, not just notify them. And that is something that we find happens quite a lot and is an issue. Now, the only situation where that could be allowed is if the proxy has agreed to delegate the power to a member of the care team, for instance, the care home manager. If the proxy had said they're happy to have medication changes without their consent, then they can delegate that power and that must be recorded. But if they've not delegated the power, then it is incumbent upon the prescribing physician to consult and obtain consent from the proxy. But while the proxy needs to consent to new medications, increases in medication, they don't need to obtain consent to stop or reduce medication. A bit like you or I go to the doctor. We can say, no, we're not going to take that medication. We can refuse our consent. But if the doctor decides to stop prescribing something, we can't demand that they can prescribe it, and the same situation applies. There's also the dispute resolution issue. So what happens when there's a disagreement about treatment between the proxy and the practitioner? If the proxy will not consent to a treatment and the practitioner feels that that treatment is necessary, then they can't go ahead and prescribe it, they can't go ahead with the treatment, but there is a dispute resolution process, and that's section 50 of the Act, and that involves the physician contacting the Mental Welfare Commission, and we would appoint an independent practitioner who would meet all the parties and determine whether treatment should happen or not. Now, if there's still disagreement after that, there is a further appeal process to the Court of Session. Now, that process can take a lot of time. So if treatment to save life or prevent serious deterioration is required during the dispute process, that can still go ahead unless there's a court injunction against it. And like I said before about not providing treatment, non-provision of treatment would not be subject to a dispute resolution process. If the issue is that the proxy wants a treatment provided and the doctor will not provide it, then that would be dealt with within the health board. Either they could ask for a second opinion or they could use the complaints procedure, but the Commission's dispute resolution process would not apply in that situation.